lawyers to the side.
The lawyers to the side?
Yeah.
Yep. And then
Just not in here.
Oh, you mean to the side?
Yeah. Like no lawyers on
I'll
camera.
go live now, and then just let that screen for 6 seconds, and then you see the starts.
And then is there someone from
So I need people to like curve. Can you step down one? Thank you.
Yep.
Right. Maybe step right here. Oh, I don't want to make sure you're not hidden. Yeah, sorry. Maybe the two of you can switch. Sorry.
It's not gonna work.
You know you're in front of other people.
It's not gonna work.
There's a light room, a minute of the hour. Almost ready.
Yes.
Let's maybe do you want to stand?
I will try not to be nervous. I will try not to be nervous.
Yeah. Perfect. Yeah. Wait, thank you. Standing off to the side.
She started behind the fence, so we're already
Okay, so we have one. And apologies that I don't know who the community is associated with, but someone from Thank you. Virginia Highlands.
Can everyone like take a step that way?
Amy.
He was here.
No, I don't think you need that.
And then Baconton.
You all are the people of the hour. I'm just talking.
So I'm kicking off listing co-plaintiffs.
Okay.
I'm just going to say, as a lead litigation counsel, she'll be sharing remarks on the case and today's opening arguments, opening statements, or arguments. Then I'm going to read that. Or I can skip it. Great.
That's great.
Okay. We'll be ready in just a minute.
Okay.
Okay, so after organizations, and then I say we're also joined by. Great. I think we wait on anything else? Okay. All set? Anyone? Okay. Yeah. Oh, gotta go. Great. Get started. Now or never. All right, good afternoon. My name is Shakota Espinoza. I am the Director of Communications for Fair Fight Action, one of the 6 plaintiffs in the federal lawsuit Fair Fight Action, Inc., v. Raffensperger, which began trial today. Behind me are representatives from the plaintiff organizations who our counsel, Allegra Lawrence Hardy, will introduce momentarily. We're also joined today by Ms. Hardy, who is the lead litigation counsel for the plaintiffs. In a few moments, Ms. Lawrence Hardy will be sharing remarks on the case and today's opening statements, followed by a brief Q&A. Since the start of this lawsuit, Fair Fight Action has centered real voters and their stories because we believe that is one of the most effective ways to demonstrate the barriers of Georgia's election system. This will continue throughout trial, where more than a dozen Georgia voters from across the state will testify about the obstacles they faced trying to exercise their fundamental right to vote. The voters traveling to trial are just a tip of the iceberg, as they represent countless voters in their communities who have been shut out from the voting process. Our hope is that by memorializing these stories in an official court record, we will help shape the future for Georgia voters, in addition to becoming a critical piece of our history. And I will now turn it over to Ms. Lawrence Hardy.
Thank you. Thank you all for joining us here on this very exciting day. I am Allegra Lawrence Hardy, and I am privileged to serve as lead counsel on behalf of all of the plaintiffs in the Fair Fight Action versus Raffensperger litigation. Many of you were with us 3.5 years ago when we filed this lawsuit. It was a little chillier that day when we stood in front of this courthouse. More than 3 years later, after we filed that suit that challenged the constitutionality of Georgia elections practices and alleged violations of the Voting Rights Act of 1965, we finally had our first day of trial. Today marks an extremely important moment in history. This morning I quoted Congressman Lewis in my opening statement. I'm now going to quote my new Congresswoman, Nikema Williams, who said, quote, "Those who came before us sacrificed too much for us to turn back. In the spirit of good trouble, Congressman John Lewis taught us we must protect the sacred right to vote for future generations," close quote. That is what we are here to do today. After repeated attempts by the state to silence the voices of the voters by asking this court to throw this lawsuit out multiple times, these Georgians refused to be sidelined. So we are finally here. We have finally had our first day of trial, and these voters are finally going to have their stories told in the first voting rights case to be tried on the merits in the Northern District of Georgia in over a decade. This case is also among the first full trials involving a claim under Section 2 of the Voting Rights Act of 1965 after the Supreme Court's Brnovich decision, which so many of you covered last summer. I am pleased and honored to be joined here today by individuals who represent all of Georgia. These are voters and would-be voters who are at the heart of this case. These are the volunteers who work at the grassroots level to protect voters every day. It is the Georgians who have always been at the center of this case, and they will be at the center of this trial. The court will hear directly from voters and those who tried to vote but were disenfranchised. The court will hear from these Georgians who were burdened and disenfranchised because of the Secretary of State and State Elections Board's policies and practices. We are pleased to be joined in this litigation by 4 Georgia-based churches. Ebenezer Baptist Church, the spiritual home of Dr. Martin Luther King Jr. and his father, Martin Luther King Sr., as well as the home church of the late Congressman John Lewis, whom we all know was a tireless advocate for voting rights. We have Beckington Missionary Baptist Church of Liberty County, a congregation dedicated to civic engagement, demonstrated by its rich history, formed as slaves became free and decided they wanted to worship on their own and decide their own values. The 6th District AME, leader of more than 500 AME churches in the state with a mission of advancing social justice, and the Virginia Highland Church, a leader in the fight for moral, spiritual, and political change. We also have 2 civic organizations, of course, Care in Action, and we heard from Care in Action today on the stand. This organization is dedicated to advancing the rights of domestic workers that also traces its roots right here to Georgia. We all learned that today while she was on the stand. And Fair Fight Action, a voting rights group committed to educating and engaging voters, particularly in the historically marginalized communities across our state. These leaders, who I stand shoulder to shoulder with, represent so much more than a name or a building. They represent entire communities that share as a core value the importance of the fundamental right to vote. In opening statements presented this morning, we outlined how, through deliberate choices, the Secretary of State and State Election Board have erected a series of roadblocks that impose unjustifiable burdens on eligible voters and would-be voters in violation of both the Constitution and the Voting Rights Act. The practices challenged in this case permeate every stage of the voting process, and they compound the obstacles Georgians face when trying to exercise their fundamental right to vote. We first challenged the Secretary of State's exact match policy. Two components of this policy that we challenge, both the method of which an applicant's U.S. citizenship status is verified and the way in which an applicant's identity is verified. We raise and are extraordinarily concerned about the rates at which registrants of voters of color are placed in MIDR, the pending status, at a rate that is up to 10 times higher than that of the rates for non-Hispanic white registrants. Our experts will testify to this. We'll hear from a would-be voter who became a naturalized citizen after she was adopted from Korea when she was just 7 years old. Many years later, after presenting her naturalization certificate, her Social Security card, her out-of-state driver's license, her marriage certificate, and closing documents. What else could she possibly have had to present? All related to her residence in Georgia. She was denied a Georgia driver's license and therefore denied the ability to register to vote on the basis that her citizenship could not be proven. Just one example. The second practice we challenge is the mismanagement of the voter rolls. In 2018 alone, Georgia removed over 68,000 voters because of felony convictions. This was the largest number of felons removed from the rolls by any state in the nation. We will in this trial hear from a voter who experienced issues resulting from Georgia's mismanagement of the voter rolls. After he completed his felony sentence, he registered to vote for the 2020 general election. After registering, he logged onto his My Voter page to check his status, and while his personal details were correct, the voting district, precinct name, and polling place were not. He sent several requests for assistance to the Secretary of State's office. All of his requests went unanswered. The issues continued when he requested an absentee ballot, which he never received. With no assistance from the state, he finally figured it out on his own and made arrangements to vote early. It shouldn't be this difficult. Finally, we challenged the lack of training regarding the cancellation of absentee ballots. In 2018, you all remember this year, that's when we filed this lawsuit. The average wait time for a Georgia voter was 21.7 minutes, or 2.5 times the national average. We have evidence that when a voter must cancel their absentee ballot, it takes even longer. For example, we'll hear from a voter from Cobb County who initially requested an absentee ballot, but later decided to cancel his absentee ballot and vote in person. He had a long day at the polls to make that happen. Throughout this trial, we will demonstrate the numerous and various choices available to the Secretary of State and the State Election Board to protect access to the ballot and cultivate uniform practices across the state so that an eligible voter can be as successful in making their voice heard in one county as in another. And in stark contrast to the options available to eliminate unjust and discriminatory barriers in Georgia's election system, we will show at every turn the Secretary of State and State Election Board's actions that demonstrate an intent and evidence of disenfranchisement of Georgia voters. It is a true privilege for every member of this trial team to join with the brave voters, the brave would-be voters, the persistent volunteers to advocate on behalf of the powerful, diverse, dedicated organizations represented by those who stand here with me. Their perseverance and, yes, their faith have brought them through voting challenges and over 3 years of litigation, through COVID, through motions to dismiss and motions for summary judgment and trials being reset to this day. And we look forward to using these next few weeks to amplify their voices and share their experiences with you. We thank you so much for your time today. And we will now take questions. Yes. You sat there so patiently all day today.
Very interesting stuff. Brittany Gibson from Politico. Why are you not ready to present remedies yet in the trial portion? Or that was part of the discussion that came up today with the judge.
Thank you so much for that question. We are very ready to present remedies. You can see that big group of lawyers up there. There's a whole remedy section. We're excited to produce remedies and to share them with the court. The concern that we have is that there has been a little bit of a cat and mouse throughout this litigation where we say, you should do this, and then the other side says, oh, well, maybe we're already doing that. And so, for example, for those who were around when we filed our TRO around the purge, and we said, we think you're doing it wrong, and literally 2 hours before we showed up for the hearing, the state restored 22,000 voters, right? So if we had put in a brief that morning, right, what the remedy was, we would have ended up in a different situation because the facts were changing. So the suggestion you're referencing is when I today said, Your Honor, we'd love to go ahead and get the whole case in so that we're not chasing after illusory representations, right? But that we know what the case is. But I certainly understood the court's ruling, and we're delighted to present our remedies when we finish our case. And we were really excited that the judge said, and then we can come back and rebuttal, right? So we were absolutely ready. We just didn't want to get in a situation where we're chasing after facts that we don't yet have because they're not in the record, though we have understanding of them from other places. So we are quite ready.
We are going to hear the stories from voters who are affected by these policies in Georgia, but we're also going to hear from the state who say it's not a major problem, that all voters have some problems, and that this is small scale and not anything that voters should be worried about. What do you say to that? How do you refer to those who say this is widespread, that this affects a handful of people?
It's just so contrary to our personal experience for those of us who have been working in the battlefield of this. We, of course, heard from tens of thousands of people back in 2018. And to me, what's really extraordinary is that 3 years later, people are still showing up to talk about it, right? That voters who have never been paid a dime, right, who have, as I said, had to go through COVID, gone through everything we've all gone through, are still taking time out of their busy schedule, right? That we have volunteers, right? People who are working, who are this committed, who are working for free, organizations whose resources are being completely diverted because this problem is so widespread. And what we know is that for every person who takes the time to do a declaration, excuse us, thank you. For every person who takes the time to do a declaration, we have lots and lots and lots of people for whom they'll never have a declaration done, right? That's too much trouble. They've got other things to do. They've got to move on. And we also know, particularly for low propensity voters, that going out one time if unsuccessful, they may never try again. The other thing I would just really encourage you to take a look at, and I know you have, is all the good data from the experts in our case. We have 14 experts in our case who really document the true issues. When you start looking, for example, at those 2018 felony numbers, when you start looking at the stats from our expert that shows that the way in which exact match applies the citizenship identity check results in a 43% error rate, right? You start to really see the gravity of the issue. So the declarations are but an example, and we believe every declaration stands in for hundreds, if not thousands of people. And I want to remind you that Verified Action has collected over 3,000 declarations. Yes?
A lot of people associate this case with Stacey Abrams and her 2018 run. Was it a deliberate choice not to mention her or that race in your opening statement today?
I appreciate the question. The parties in this case are Verified Action, Ebenezer, Baconton, Virginia Highlands, etc. And so this case is about all Georgians. It's about removing these insurmountable barriers to voting. And so we really don't see it as having any relevance to any particular party, race. One of the great privileges of a lawyer's life is to spend time defending the Constitution. I can't think of a better way for me to spend time, and there's just nothing partisan about democracy.
The defense team, though, in their opening statements, did kind of draw that comparison and did some comparisons with the post-2020 litigation. Do you have any response to that?
I certainly heard that, and I understand why they might like to make it partisan, but we believe the Constitution protects everyone. All right, thank you all so much for coming.
Thank you. Appreciate it.
Thanks.
You'll see how they go.